Hello, America. I'm Mark Levin, and this is Life, Liberty, and Levin Sunday. Thanks for being here. We appreciate it. The Supreme Court has a couple of monumental decisions to make, and I want to address one of them tonight. That's right, a decision that will affect foreign policy, a decision that will affect commerce, but more than anything else, a decision that will determine separation of powers and what this country looks like going forward. You might not think a tariff case is that big of a deal, but it is a big deal. And I want to get to the bottom of this so you know more than anybody else. And that's why I appreciate you, the smartest of smart audiences. So let's get started here. The truth is, and I'm going to put this in a bigger context now, the truth is that most legislating, even tariffs aside, occurs in the executive branch. It's not the way it's supposed to be. That's not what John Locke told us. That's not what Montesquieu told us. That's not what the Constitution provides, separation of powers, three branches. But that's the way it is. And under Democrat administrations, the breadth and reach of that executive legislating is massively increased and expanded. How doesn't this violate separation of powers? In fact, efforts to oversee this by Congress are, for all practical purposes, limited to Congress's passing laws to modify or stop it in specific cases or broadly. Congress has created this situation. Congress can end it, but it can only end it in certain ways without violating other aspects of the Constitution. So let's start right here. Again, this has everything to do with tariffs and a heck of a lot more. The executive branch now encompasses over 200 agencies and employs around 2 million civilian employees. I'm not even talking about federal contractors and all the activity downstream. In 2024, the U.S. Federal Register, that keeps note of all the regulations and publishes them, including the ones that are being proposed, reached a record 107,000 pages. Over the last 12 years, 1 million pages. And this 2024 Federal Register contained 3,248 new final rules put out by the Biden regime, with 45,000 pages dedicated to those final rules alone. As a side point, how are we, you and me, Mr. and Mrs. America, even know what this is all about? You don't. A recent report from the Competitive Enterprise Institute, the 2025 edition of the 10,000 Commandments, highlights the staggering impact of federal regulations on the economy. It estimates compliance with burdensome federal regulations has an annual impact of at least, ready for this, $2.155 trillion on the economy. Stick with me, this will all make sense. This represents a substantial burden, obviously, on U.S. households and businesses alike, which is further exacerbated by federal fiscal mismanagement that has generated a gross national debt of over $36 trillion, now $38 trillion and climbing. Remember, this is 2024, 2025, looking back at 2024. Most regulatory costs are embedded in prices of goods and services, never show up on a receipt or an annual statement. Regulations can affect households directly. They can occur indirectly. Businesses pass regulatory costs on to consumers just as they do the corporate income tax. Other regulatory costs find their way to households in the form of lower returns on retirement funds and other investments, as well as fewer investment opportunities and more paperwork if one were to allocate annual regulatory costs, assuming the full pass-through of cost to consumers. U.S. households pay $16,016 annually in embedded costs, or 16% of an average income before taxes, and of course, these are really after taxes. Using the $2.155 trillion baseline, the hidden regulatory tax exceeds every annual household expenditure item except housing. Where did the executive branch get the authority to do all this? All these regulations are taxes. Indirect, some of them direct. They're costs placed on you, Mr. and Mrs. America. By whom? By the executive branch. Through regulations. Produced by whom? The executive branch. At the behest of whom? Congress. Is that not a violation of separation of powers? Stay with me. Congress is given with one hand all that, but says now, well, we need to at least have a role in the legislation by regulation. And what are they going to do about it? Well, they've tried a few things. They've tried a legislative veto. Here's the problem. It's not in the Constitution. The only person that has a veto is the president of legislation that reaches his desk. And the Supreme Court so said in 1983 in a case called Immigration and Naturalization Service versus Chadha. Congress has no veto power. Congress passed the Congressional Review Act in 1996, which allows lawmakers to use an expedited process to repeal some kinds of agency regulations. That sounds good. Congress can do that. But Congress rarely does, because Congress is a massive body of egomaniacs, so it doesn't happen. The so-called REINS Act, which is actually based on one of my constitutional amendment proposals in the book Liberty Amendments, would require Congress to pass a resolution of approval for any new proposed major rule by any agency. A major rule would be a rule that has an economic impact of $100 million or more. What does this have to do with tariffs, Mark? Everything. Conversely, Congress has taken some affirmative steps to do what? To empower a president when it comes to things like tariffs and trade. What have they done? The Trade Expansion Act of 1962, Section 232, and the Trade Act of 1974, Section 301, explicitly grant the president the power to impose tariffs under certain conditions like national security threats, unfair trade practices, and so forth. The Supreme Court has upheld Congress's ability to delegate such authority. Foreign affairs powers. Tariffs aren't just about taxes. In fact, they're more about foreign affairs. What are they? They're the imposition of costs on foreign governments. So they're not mutually exclusive, taxes, tariffs, and foreign policy. There's no easy way to bifurcate that. Foreign affairs, Article 2, Section 3, Clause 1. The president is commander-in-chief. The president has plenary power and responsibility for foreign policy and national security, period. And the Supreme Court has recognized that in multiple decisions as well. Now, we have the International Emergency Economic Powers Act. This act allows the president to regulate imports during a declared national emergency, authorizes the use of tariffs. It provides broad language to regulate tariffs. And the court should defer to the president's determination, is the argument that the president is making in courts. So what about the constitutional authority of Congress? Stay with me. I'm giving you a lot of information, but it's going to add up in a moment. Article 1, Section 8, Clause 1 of the U.S. Constitution. Congress has the power to lay and collect taxes, duties, imposts, and excises. And then we have the Commerce Clause, Article 1, Section 8, Clause 3. Congress has the power to regulate commerce with foreign nations. Well, doesn't this trump everything else? Doesn't it? No, not in the least. So you see the complexity of this. People are saying, tariffs are a tax and that's it. You know what we call that? Stupid. Here we go. What does it all mean? First, Congress's core power is legislating. It is the legislative branch. Second, yet most legislation actually takes place in the form of regulations, which Congress has delegated to a massive bureaucracy within the executive branch, and which delegation the Supreme Court has upheld, finding no separation of powers issues or non-delegation issue. Now, honestly, to me, that's absolutely crazy that the executive branch, put aside who the president is, who's in Congress, that the executive branch does more legislating than the legislature, Congress. It kind of defies what was intended. But when you have a massive welfare state, like America has become, even with all the important cuts the president has made and Elon Musk has proposed and so forth and so on, it's still a Leviathan. It's still a Leviathan. So the Supreme Court has upheld that. So if you think about it, that's really incredible. But let's move on. Third, regulations are taxes, pure and simple. Their costs are hidden in the cost of production, the cost of products, and so forth. In fact, it is a massive tax instituted by, ready for this, the executive branch through its regulatory decisions. Now, Mark, you just said it's not a tax alone. It is not a tax alone. But it is a tax. And who issues the tax? The president, when he puts in place tariffs. Again, you can see the ambiguity between the separation of powers and the authority of Congress. But it's more than a tax. If you really want to get back to the original understanding of separation of powers, you'd need to address this, which would change everything. So when The parties opposed to the president and his tariffs say, it's a tax, it's only a tax. What they're really saying is, we got to go back 100 years and fix this, because the president is laying a tax, and the power to tax, the power of the purse, belongs with Congress. You won't hear the left say that, because they want the executive branch to tax. But that's not the final point either. Fourth, the president has plenary power, very broad constitutional power, is recognized by the court on several occasions, to run foreign policy. It was understood at the Constitutional Convention when they created the presidency. It's understood today that Congress is neither functionally capable of doing it, nor was created or authorized to do it. So if a tariff is a tax, we have the executive branch taxing. If a tariff is about foreign policy, that is a power that is a plenary power, a broad power, that belongs to the president. Fifth, unquestionable, the power of the purse rests with Congress, even though Congress has granted the indirect taxing of goods and service through regulations to the executive branch. I can't emphasize this enough. I'm not happy with it. In fact, I've spent my career fighting it. But this is what we're faced with today. And I cannot allow the party against what the president is doing to claim, hey, only we have the power to tax, when regulations are costing us trillions in indirect taxes and costs, and they're happy with that. And when these same parties, Democrats, control the executive branch, they use the regulatory powers to tax as much as they can by regulating as much as they can, and yet they reverse course when it comes to the president and tariffs. Sixth, Congress has in fact delegated tariff-making power to different degrees to presidents throughout our history. Whether that kind of delegation is required or not, that's what they've done. Okay, so now what? The Supreme Court should reverse the lower court's decision that ruled the tariffs unconstitutional. That decision was way out of line. The president's tariffs are not unconstitutional. But it doesn't matter. Mark, what do you mean? Stay with me. The Supreme Court should hold that this decision is not justiciable for the courts, including them. Certainly not now, given all the factors I just laid out. In other words, there's no clear constitutional or statutory or precedential basis for the 9 justices to decide what has never been resolved since the institution of the Constitution. This is a matter for Congress and the president to work out, if they work it out at all, or if they decide to work it out at all. Tariffs involve foreign policy, they involve taxes, they involve commerce, they international commerce, they involve national security. They involve the whole works. So why should the Supreme Court get involved in that? Why would they get involved in the middle of this and try and sort it out when they can't sort it out, when we haven't sorted it out through the entire history of our country, and it's still not sorted out between Congress and the president, and that perhaps is a good thing, not a bad thing. And despite all the talk, Congress has taken no legislative steps, none at all, to counter the president's tariffs. None. Instead, the case comes to the Supreme Court through litigants who represent various industries, or other courts through politicians who represent mostly themselves or a single party. But it has not come by way of Congress, neither the House or the Senate. So the House and the Senate have done nothing legislatively, and the House and the Senate have not gone to the Supreme Court. So why are we here? The court should take a pass. It's that simple. It should reverse what the lower court did, and it should tell the courts, stay the hell out of it. All 700-800 lower courts, can you imagine? If the court does not, there will be a ton of confusion and governmental and economic dislocation and chaos. Why? Well, for example, when is a tariff a revenue-raising function or a foreign policy national security function? How do you make a distinction, given it has an impact on both? And who's to make that distinction? Lower court judges? Imagine what a disaster that would be. Why? Why should they make that decision? They're utterly unqualified to do it. Why? Because people decide to bring a case, some industry, some individual, some local politician, private litigants. Where does that end? And won't that create havoc? And certainly, conflicting rulings among lower court judges, we see that today. That will do grave damage to our economy and our foreign policy. The uncertainty would be devastating. The economic and foreign policy implications could be disastrous in specific cases, for sure. Sometimes you just leave well enough alone. Sometimes you just leave things alone, let them work out through the political process, the legislative and executive flexibility or battles that take place, not a handful of lawyers substituting their judgment for that of the body politic. This is not about whether one likes or dislikes tariffs. That's policy. This is about the proper role of the judiciary and a battle between the branches, the elected branches, that has swayed back and forth since the Constitution was ratified. And even now, there's no battle between the two branches because the House and the Senate, collectively, Congress has not brought a case and has not passed any counter legislation. So to put a fine on it, there's no conflict between the president and Congress, just talk. No challenge, no litigation. You simply cannot categorize tariffs as purely the imposition of a tax, even though it is a tax, which gives the argument to the president. They've delegated that authority to the executive branch through this massive bureaucracy and regulations that are taxes for sure. And I'm just making the point that you also have foreign policy considerations. You can't bifurcate them. It doesn't work that way. And obviously, Congress can't muster any votes. It doesn't even want to muster any votes to challenge what the president is doing. So this is neither the time nor the place for the courts to pick sides. Supreme Court, just overrule the lower court, dismiss what they did, leave the status quo untouched, back off, or you will open a Pandora's box.
Hey, Sean Hannity here. Hey, click here to subscribe to Fox News YouTube page and catch our hottest interviews and most compelling analysis. You will not get it anywhere else.